okay. So now when we start bringing people on to onboard them with our financial planning services, one of the areas that they tend to like flunk on is preparation for, like estate planning documents or having anything done in that area at all. I kind of find it funny why that is. And I think it's probably just because people don't want to confront this kind of thing, like confronting like what happens to me if I die, or, there's probably some fear along with that. But why don't you kind of give us what your viewpoint is of estate planning and, your process for, when you meet with someone.
All right. And a lot of times it's just pure procrastination. People get surprised.
I don't want to say that, but laziness comes into the fray. Yeah.
Yeah. It's like, I got something else better to do, wash my hair or whatever. But no, let's talk about the 4 ways that you can basically get rid of your estate. And the first way is by doing nothing, which is about 90% of the time when I sit down with somebody, they've never really done any estate planning or anything. And when you do nothing and you die without any documents, that's called dying intestate, which is a fancy way of saying I've died without a will. And when you die intestate, basically what happens is the court will write a will for you based on what the law says. The court will also appoint somebody to be in charge of your estate that they feel that needs to be in charge of your estate. You have no say-so in it. And then they'll also do this thing called probate. And probate is where your assets get tied up in a court process and administered by the court for maybe 9, 10, 12 months or longer. And then on top of that, because you're in court, you have to hire an attorney, because that's what attorneys do, is they go to court. And the probate costs can run anywhere from 3, 4, 5, 6% of whatever goes through the probate estate. So in other words, yeah, no, exactly. It's great for attorneys, though. Don't get me wrong.
I was going to say, I mean, people don't think that doesn't sound like that's much, but then you do that on like a $5 million estate, and you're like, oh wow,
you're talking a couple $100,000.
Yeah.
So when you die without a will, you're basically saying, court, I'm not making any choices. I want this person in a robe to make all the decisions for me. This person who I've never met before is now in charge of my final disposition of assets. So dying without a will is called dying intestate. The second way of getting rid of your estate is dying testate, which is a fancy way of saying I have a will. And a will is nothing more than a written document that says who's going to get your estate, who's in charge of your estate, and this document can be amended or revoked at any time prior to your death or incapacity. You're at least now making choices as to what you want. This is who I want to have receive my things. This is how I want them to receive things. In Florida, for example, you can even put language in there that who's going to be in charge of your children if they're under the age of 18. But we're still in probate court.
Quick question on that though, Patrick. If you die intestate and you have minor kids,
the court makes the decision as to who raises the kids.
That's no good.
And that's a great question. And a lot of times it's really funny, when people sort of come out of the woodwork when there's money involved. Because basically whoever raises the kids, they're going to get the benefit of whatever's in the estate to help pay for the kids, to raise them and put them through school and whatever else. So dying without a will, intestate. Dying with a will, testate. Both go through probate. Both require attorneys. Both cost anywhere from 3, 4, 5, 6%. Right? So do the math. If it's $1 million, it could be 30, 40, 50,000. If it's $2 million, it's double that. If it's $3 million, it's triple that. So it can get very expensive very fast. And it's not hard to hit $1 million these days, because if somebody has like a life insurance policy or something like that, $1 million life insurance policy isn't out of the realm. So how do we start to move away from the probate courts, and how do we have even more control? And there's 2 ways. One is with what's called a trust. Revocable trust, revocable living trust, revocable, just straight living trust. They're all the same thing. It's just different names for the same type of document.
Why do they have so many different names for the same thing?
Marketing. Marketing. But what is a trust? A trust is a written document that says who's going to get your estate and who's in charge of your estate that you can amend or revoke at any time prior to death or incapacity, which sounds just like a will. A will is the same thing, except with a trust, what I do is I put magic language in this document, and it transforms that document and makes it something different than a will. And by putting that magic language in this document that we call a trust, I've now removed you from the probate court. And why is that important? First of all, we avoid probate. We don't have to pay attorneys the 3, 4, 5, 6%. So you save money. That means more money is going to, your kids or whoever. But also, here's another important factor. Whatever goes through the court system, I don't care if it's probate court, traffic court, criminal court, civil court, whatever court, is a matter of public record. So anybody can go down to the courthouse, pull your probate file, and see what's going on. Because the trust isn't filed with the court and doesn't go through probate, guess what you have? You have this thing called privacy.
Oh, boy.
Yes. And today, with all the hackers and scammers and nut jobs that are out there, that's an important consideration. So you get basically a double benefit. You get to be outside the probate court, but you also get this thing called privacy. So the third way of getting rid of our estate is with a trust. So intestate, no will, testate, will, trust is the third way. The fourth way of getting rid of our estate, and we use this in conjunction with the trust, is we use beneficiary and right of survivorship designations. For example, if you had a life insurance policy or an annuity or a brokerage account, you can designate a beneficiary. On a life insurance policy, usually what you want to do is designate the spouse as first beneficiary. The second beneficiary can be the trust. All right?
Yeah.
So see how it comes together. So we want to make sure, usually in most cases, not always, but most, probably 95% of the time, the spouse is the primary beneficiary and the trust is the second beneficiary. If it's a joint account, it's automatically going to go to the surviving spouse. So what we would do in that case is we would name the trust as the primary beneficiary. Why? Because the spouse is already going to get it because it's a joint account. And here in Florida, we have special kinds of joint accounts for husbands and wives. We have this thing called joint tenant by the entirety, which is a special designation between husbands and wives that provides for right of survivorship. Some states have this, most states do not. Florida happens to be one of those states that have it.